Thank you. Mr. Sahu, Mr. Bajpai, Dr. Krishnan, friends, ladies and gentlemen. It's very difficult for me to come in here cold, as it were, and give you a valedictory address, because I'm sure lots has gone on during the day, and what therefore I might say could be a repeat of what you might have heard during the course of the day. If that be so, please bear with me. I'm also not a legal expert. I'm a mere economist, so I may not be able to get into the sort of complexities that you may have wanted me or the valedictory address to get into. And then finally, I start off with another, if you like, regret, which is that I think it's because of me that the last session was cut short. If so, I hope you'll get a chance to interact over tea with the panelists. Ladies and gentlemen, having said all that, I think my first point must be to congratulate Mr. Sahu and his team to have set up this institution in such short time, and for this institution to have passed the test on the ground. It's not often that you have a law that gets passed and gets enacted and then actually proves its worth in as short a time as the IBFC has done. As you know, this process started with the budget in 2014-15. When the announcement was done in August 2014, the Bankruptcy Law Reforms Committee was set up. November 2015, the report came. 21st December 2015, the bill was introduced. And 28th May 2016, the Insolvency and Bankruptcy Code came into effect. Now, 2016 May and 2018 December is just about 2 years, and we already think of the Insolvency and Bankruptcy Code as being part of our institutional statutory setup, and it's become sort of like as if this is like sort of a regular thing, and people have accepted it. And I think the reason for that, and that it has become such a, if you like, a part of the normal practice and part of the norm of corporate behavior, contract enforcement, of all that, is because the team has worked so hard and so diligently in putting this together and getting it to act and getting into effect. Also, of course, this does mean that that the team of professionals which has had to be created from scratch has also been done. And I think that itself is again a very big achievement. And this is therefore a law, an institution which has been transformative in its nature rather than just as business as usual, and yet has almost hit the deck running and produced the results that we have seen. Huge improvement, you can imagine. I think the World Bank's ease of doing business used to give us something like 10 years on average for exit, for corporate exit in India. 14 to 15 years was the kind of norm, and this has now been reduced. The deadline is 270 days, and I know that out of the something like 816 cases, 213 cases are more than 270 days old, but large number of them are because they are in the court, and the court has said that as long as there is litigation, the time clock must stop. And I suspect that there is a case here for some kind of an amendment, because otherwise we will defeat the purpose of this law. If the deadline is 270 days, but then somebody goes to the court, we are such smart, clever people in India that we will take that recourse, and that everybody would start going to the court, and then it can again become an unending process. So I think maybe if, and I don't know what the discussions have been in the morning, that if 29A has to go back for some minor amendments, in future, then maybe perhaps this is one of the places that you might need an amendment whereby courts may have to decide a time limit for themselves if they are going to deal with cases which come to them through the IBC, through the NCLT. So that's one. So therefore, wonderful. I think this has been a great achievement, and also I think because this is now, it has restored the sanctity of the debt contract. It has sort of made it more creditor friendly, and in that sense created a level playing field between the creditor and the debtor. I think this is very important, because otherwise the creditor was always at a disadvantage. And I think all of us would agree that so far the debt, especially from the financial creditors, that you had, the situation almost was that all the downside risks were that of the creditor, and all the upside was that of the debtor, and there was no downside. And I think that's changed. That's begun to change. Now people have realized that you are not you can't just simply take the creditor for a ride and then carry on for long years without having to repay that. And I think that's something which is of course a huge improvement. Now, if you going forward, I think I've been told that there is a issue with, and I'm sure this has come up with a lot of discussion, that the introduction of Section 29A, which debars the promoters from bidding for the assets that they have, and there are questions as to why, even if you are willing to pay almost the full amount of the debt, why should they be debarred? And the question has arisen is that why didn't they then agree to pay in the first place itself? My own thought in this is that maybe one could think, and if you are going to, in any case, go for amendment to the 29A in the case of medium and small and medium enterprises, where there is a case being made that the small enterprises sometimes lose out because they don't have the necessary cash or the necessary wherewithal to tide over. There's a kind of a cash crunch, and in that case, their assets go out of their hands because some people move. So there is a case being made for some leniency towards small and medium enterprises. I'm not so sure of that. I think it deserves a look. My only point is that in case you do go for that amendment to the 29A, maybe what you need to think through is that if suppose the debtor, after the case has come to the NCLT and it has been moved, if at that point even he or she is willing to pay 100% of the debt right away in one go, why should that not be permitted? Now that's something which I hope will not raise a controversy. My only thing is that the idea is, the thought was, I believe, when the 29A was introduced, that the promoters should not, in some sense, get a preferential treatment, because everybody will then try and, this is why they were debarred. You were debarred because you haven't paid it, so therefore now in some sense you pay a penalty, and why should you be allowed to bid, as it were, for their assets to come back to your own management, which you have mismanaged before. But in case you are willing to pay the whole 100% of the outstanding debt, and maybe outright or maybe in one or two tranches, would it not be sometimes better for the promoters or for the former management who does know the firm and the sector all right, to be able to get hold of those assets once more? Now, if that be a condition, then maybe some problems would get solved, and maybe some of your cases that are now being litigated in different courts could also be resolved. So that's one suggestion for you, Mr. Sao, as you go forward. So that's and the second one, of course, is that you do need, I suppose, different liquidation mechanisms, different sets of courts, different set of expertise for different sectors. And can we then further, as we go, I'm sure, as the IBC process gets matured, we'll get further refinements, we'll get further, expertise, we'll get more and more professionals, dealing with some particular specific sectors, and therefore you will get these sector-specific, thing. Now there are at the moment I'm told about 2,000 registered insolvency professionals and 3 professional agencies in the country, and 50 insolvency professional entities registered with the regulator. I'm sure this number is bound to grow, and as this number grows, therefore, they will emerge specializations within these numbers, which will help the process going forward. I think one of the better things that has happened already, and I'm thinking about what else is there in the way forward, is the Supreme Court judgment by which the real estate buyers have been given the status of creditors. I think that's a very good improvement. But is that something which will what is its impact on the real estate industry? I'm not so sure, because you got the RERA there already, and you got this. So could there be a regulatory overlap here? Could there be something that puts the builders, even the some of the more honest ones, at a disadvantage vis-a-vis the buyers? There's something that we need to be thinking through. We are still, despite all of this, if you look at the ease of doing business rankings, India's rank in resolving insolvencies is improved from 136 to 107 in 2018. So we still got about 100 places to go. So there's a huge. Now I'm not clear, and this is, I think, this is perhaps one of the tasks in front of us, which is to chart out a path whereby we can improve these rankings as we go. And there's a huge scope here. So while we must congratulate ourselves, we must also know that there is still not time to relax and be complacent, because we are still 107 on ease of doing business in terms of resolving insolvencies. The average realization rates are still, I think, not as good as they should be. They're about 46%, or is about 46%. I think the global average is higher. And again, as the process matures, we will probably see these going up. And also because a large number of these cases were those which have been outstanding for a long time. So those, in some sense, the very poor cases came for this process. So therefore, the recovery rates has therefore expectedly been lower. But as you get more even of the debtors coming to the IBC, I think, and as you get more creditors quickly moving in, I think this will improve. My most expectation, the biggest expectation that I have, is on the impact of this process on the economy in the general, because I think this should, in my view, at some stage, maybe not now, maybe 3-4 years down the road, I don't know when, it must have an impact on credit availability, the cost of credit, the cost of capital, and therefore overall economic activity in the country. If it enables, at the moment there are hardly a few hundred resolved cases and about 816 ongoing cases, etc. So I don't think the database is large enough. But as data accumulates, and as it lends itself to much more data analytics, and as it lends itself to cutting it and splicing it in different ways to figure out the features of those entities which perform better compared to those which actually end up in the insolvency processes. Once we are able to do that data analysis, identify the features which make for good borrowers compared to those who make for bad borrowers, etc., I think banks will be in a much better situation than to make the better credit risk assessment. I hope the banks will work with you as we go forward. Also, the NBFCs will work with you, because all of us put together, I think, can make very good use of this data. My hope, therefore, is that this process will take much greater depth. It will take roots. I hope the government of India provided all the resources necessary to build the capacity within NCLT. I think at the moment we are stretched. We need more. We need more resources. We need probably, I'm not sure whether you have provincial offices, branches already. If not, I think very soon You should be, and at some stage, we need to think through moving from, not moving, as to how to bring more and more the small and medium enterprises into the process, so that this duality between the formal and the informal sector, between the organized and the unorganized sector, tends to become more diluted, more diffused. So in the very end, I hope we will be able to adopt a more flexible approach to different cases. I hope the RBI will give you also more and more space, to deal with this, with all the banking cases that come to you, and I hope you'll be able to expand the research and the database, which will be helpful to the entire economy as we go forward. Thank you all very much for listening to me, and congratulations once again.
Dr. Kumar has kindly agreed to take a few questions. Okay, then we close. Please. Please.
I didn't quite understand what you meant by saying if the debtor repays the entire amount, at what point of time does he repay? And if it is after 9 months after he defaults and is still not being penalized, it would send a wrong signal probably.
No, my thought simply was that you get all the time that you do get before the process starts. And in fact, thank you for asking me, because I also had in mind to say that there might be a benefit also in putting in place a mediation institution before cases come here, so that they can get resolved. I think some of them do already get resolved, because of the, in some sense, the fear that the case will come here. Some of them do, and I have a number here that large number of cases have been resolved out of court, as it were. My thought was that once you get into the court, and you can impose a penalty, but the original promoter is not allowed to bid. That's not the case. The only condition is that if he or she is willing to pay the entire amount outstanding, right, at that point of time, once the process has come to the court, then isn't there a case for them to be given back the management? If you want to put a penalty there, that's up to you. And maybe the interest rate will already be included in that outstanding amount. So it's not just a question of paying the principal. But I'm just simply saying that why debar a promoter completely in case the bank, the creditors get everything back?
No, actually, I think the aim is to send a signal
Yeah.
for debtors to change the behavior moving forward.
Yeah.
Now, if the penalty is in terms only in financial terms and not in terms of debarring, the signal is very different.
I'm not sure. This is exactly what I'm trying to say. I'm not sure what is the strength of the signal that you need. There's a personal view. Of course, the law is what it is. I'm merely saying that if you are going to move, and remember my caveat, that if you're going to amend 29A for some preferential treatment to MSMEs, so that you are going back to the drawing board at that point, the signal to the debtor, in my view, is already gone. Everybody knows that if you are not following what you are supposed to, then you are in the court and then you will get a haircut, right? But at that stage, if you can impose a penalty, you can make a clause there that you will pay, X% more or whatever, principal plus outstanding interest plus some penalty. But something, if it is available, because what I find sometimes, why am I making this argument as an economist, that the original manager, who's there, does perhaps have as much or a better knowledge of the industry or the conditions in which he or she is operating. Very often also the workforce or the vendor system, etc., etc. So isn't there an advantage in having that one provision, which is a very stringent provision already? All outstandings, along with the penalty, if you like, if that is made available. And by doing so, who is harmed? I don't see any deleterious impact on anybody else. So that's the thought.
Mr. Das?
Dr. Kumar, just on that point, and I was going to pop up with that question next. I work in distressed investments, and I think in this situation, the overall harm that is done is
The overall?
Harm that is done is, in the long run, you won't have actors that will perform the function of either price discovery or trying to come in and turn around assets. I think the moment in these processes, especially in the context here where for 30 years, it's been a tradition of grand larceny at the expense of the general public because you take bank monies and don't return them, the moment an entrepreneur, a promoter is able to figure that if there is not enough interest in an insolvency process, then there is a low threshold. And if there seems to be interest, then they need to bid up either the full value. You will squeeze out, in the medium term, you'll squeeze out other actors. Bidding is a very costly exercise. Market actors decide what that bid is.
Just try and understand this. There is a asset now in court, right? And where the bidders, let's say, have said 40 pence, 40%, 50%, whatever they've said. And for some reason, which will be unclear to me, the original promoter says no, 100% plus this. Now, this case may be quite exceptional, but in case it is possible, where would the asset, the asset managers or the bidders, how would they lose out? How would the economy not gain and the debtors not gain? They will not get a haircut. They will not have to suffer a haircut.
They'll suffer one in the future for all time to come.
Why?
So take a simple example. Take an Indian company that runs 50% cash and 50% on book, right? The promoter has the privilege of owning 15% of this company, enjoying the entire cash profit, and the 15% recorded profit times whatever it is.
5% was cash.
No, let's say 50-50
Huh.
in my example. So 50% of the income that's generated through the cash business in some of these companies goes purely to the controller of that company. Now you have outside parties examining the books, trying to determine with very limited knowledge at best what they can do to try to turn this company around, come in and help revive the asset. And if the promoter owned 15% of that company, then they enjoyed 15% of that profit times whatever multiple, say if it's a listed company. So sometimes the ability of outsiders to come bid here is actually deterring at a secondary level all kinds of stuff and shenanigans that carried on. And in that situation, the amount of work required to come get to, if it's a reasonable market, there are 3 guys bidding, 5 guys bidding, they've made their effort to find that 40 price. The next time round, in our business, generally when you're bidding in an auction, if someone has a right of first refusal and an advantage, informational advantage, you want to stay away. So over time, I think this is going to have a very deterrent effect if, in fact, the field's opened up. In the short run, there is pain, and as a person who's a creditor half the time, I obviously preferred the idea that instead of getting 40 from a bidder, I'd get 100 from the promoter getting out. But I think long term, we'll end up with a situation where all the issues that were there in the past will actually get perpetuated. So in my personal opinion, this 29A actually is the linchpin that caused IBC to start to work. The first 5 months were just a holdout. As soon as this came into effect, the game's changed, how things work has changed, creditors have started to matter.
Well, I'm no expert. That's just in fact, it's not even part of my notes what I said, but, and I can't therefore argue it here, but I think it's something that at least I would like to discuss in a closed door session in much more detail, because I'm still in my mind not, the conditions that you've now put in your argument about 50% book and 50% cash and 15% promotion. All of those are sort of contingent conditions. But let's discuss that at some point of time. Maybe with Sau's help, I'll organize a session in Niti Ayog to be able to do that.
Like relating to the point that you said, so 29A subsection C that actually disqualifies those who have NPAs from bidding, there's a proviso to that, sir, which actually says what you said, that if the person pays back the full amount along with all interest and charges before submitting a resolution plan, then he becomes eligible to submit a resolution plan.
I was referring to about the resolution plan and after. Before that, I'm aware. But the question is that until then, there is a call the bluff kind of thing going on. But once the resolution plan is there, then you know that it's done. It's a done deal. It's now in the court. And at that stage, you get barred. So my thought was that maybe the word that he used was hold out, that if you're holding out. But look, if it's not, maybe my suggestion is, something that's not been thought through. Yeah.
I have two questions. One is, today there's a lot of debate on the rights of operational creditors, whether the rights of operational creditors under the IBC, the COC's financial creditors, except in one very specific exemption. And as currently in the law, operational creditors, so long as they get their liquidation value and treated fairly, it's okay. But in Supreme Court today, there is a debate going on what are the rights of operational creditors in bankruptcy. So I would be grateful for your views on that. That's one. And secondly, this is a question both for you and Dr. Sahu. Our law is a law where a bidder must buy the full company. He cannot buy assets of the company. And so you have to buy the company. And by that I mean, if there's a environmental liability that will come upon tomorrow, you have to own that liability when it comes tomorrow. So as an economist, do you feel that we should now consider, because the Joint Parliamentary Committee had said that at some stage in the evolution of our law, we should consider an asset sale mechanism where the debtor, which is in distress, his assets can be sold rather than having bidders buy the company itself. So to summarize, my two questions are, in parts, in one whole, whichever way possible, but not, rather than being forced to buy the company as a whole, the resolution professional should have the ability to sell it piecemeal. And if that makes more recovery, great. So to summarize, my two questions for you are, what are your views on the debate on the rights of operational creditors? And secondly, do you feel that we should now consider an asset sale mechanism as well?
The operational creditors, the figures that I have here is that now there are more cases triggered by the operational creditors than by the financial creditors. The number is larger. And so far, at least, what's happened is that I believe this was discussed here also, that the recovery rate for operational creditors is also the same as that of the financial creditors. So in that sense, the current situation is that the two are treated at par. And I don't see any reason for that to be changed going forward. I think they are both creditors, and I think they have therefore an equal right in the sense there is no such thing like the preferred and non-preferred sort of creditors. I don't think that that difference exists, and I think that's the way it should be. Now, one could ask the question as to if there are both varieties of creditors available in contention, then whose dues should be met first, as it were. Now there's probably a legal procedure here, which is what is this called? Secured lenders and unsecured lenders, and I suppose operational creditors fall into the rank of unsecured lenders, debtors. So to that extent, they would have to go. So if the amount is limited, then I suppose you will have to have the secured creditors getting their dues first and then the unsecured ones. But as long as the amounts available are good enough for both, then their rights are equal and then they should be respected. On the second one, on asset sale management, I haven't thought this through because I'm not sure. The objective is clear in one's mind, which is that the maximum value should be realized of the assets under consideration. And so if there are, theoretically, at least prima facie, it would seem that if asset sale piecemeal can get you higher value, then why not? The only problem is then that there might be left a rump of the company which then remains unsold, because on which will then lie all the liabilities, that future liabilities that might be incurred. And to that extent, that one particular could be a substantial part of that company which remains unsold. And what do you do with it? You see what I'm saying? That a company has assets of different qualities, and the best qualities get sold off, hived off, and then you get remained left with whatever there is, which is liable then to all the future possible liabilities that you are saying about in the environment or the labor or whatever. So I think maybe therefore a piecemeal sale may not work. But that's my understanding at the moment, just thinking aloud. But maybe you need to look at it and then come back to it. Now here again, I think you may need different approaches to different sorts of companies, depending on their scale, sectors, and and region, maybe even the geography, and maybe one rule may not work. The same rule may not work for all. I have in mind, for example, small and medium companies, who don't have possible liabilities. They have what they have there, and if you can divide it into two and then sell it off, maybe that's the thought. While the larger ones would have different establishments, different locations, what you do with it, etc. So I think maybe one size will not fit all, and you need to have this more nuanced.
Okay, if I can supplement, as Dr. Kumar told, our experience has been the relatively major beneficiaries of this entire regime have been the operational creditors in terms of number of creditors using it, and in terms of the amount realized by them before admission, which Mr. Singh was quoting a figure of about 1.2 lakh crore. In the morning, Mr. Behram Wakil cited one data point that as of now, the financial creditors have got 46% of their amount of claim, while operational creditors have got 47%. You have seen the last order on the matter of Rajputana, where Honorable NCLAT told the hierarchy of objectives of the code, resolution, maximization, balancing interest, and didn't allow a resolution plan which was not balancing the interest of all stakeholders. So today we have enough jurisprudence whereby the adjudicating authority is looking at fairness, equity, and balancing the interests of all stakeholders. But if you make it too much of a hard coding, for example, if you say that operational creditors have to get X, then the financial creditors also will factor in that. If they have to give operational creditor that much, then they will behave differently. They will behave that they will look at, I have two options before me, resolution and liquidation. Which option is giving me more? If under resolution option I have to give out 30 rupees to operational creditor and 70 is left for me, why should I do this if I can get 80 in the liquidation? So your strategy, the policy objective should not be that, because people have contractual rights, people have a secured debt, and which you can't say that IBC will override the Indian Contract Act and we will simply forget about the contract enforcement. If somebody has an accrued right, a higher right already, and you want to force it to this process and say that I will take out that right, let operational creditors get more, I think that may not be acceptable. But having said that, you please look at the rationale what BLRC told when they gave this responsibility to financial creditors. They told that the operational creditors do not have stamina to wait for a longer time. They can't restructure the liabilities. They can't take a haircut. Leaving aside that, there was an argument that the banks may be better positioned in terms of financial, in terms of commercial assessment of a resolution plan. But the more important point they made is that the operational creditor cannot take hit. If you put him in a decision making position, he will be tempted to liquidate it and take as much as possible at the earliest possible opportunity. Now, if we believe that operational creditor cannot take hit, the financial creditor, just because today he is in a position of taking a decision, should not cause a bigger hit to operational creditor than the financial creditor should take. So financial creditor is the elder brother of the family, has been given the responsibility. The property it is there, it is not its financial creditor's property. Possible that a company has got into a process with the very first ever default of 1 lakh of rupees. There is everything intact, there is enough organizational value, there is full value for even the shareholders. But just because today you are in a position to determine the fate of everybody, you should not be pushing out everybody and take the lion's share. So actually there is a lot of behavioral, a lot of so essentially I would like that if you have seen the one of our newsletters where we have told what is the COC dharma. We do not want to hard code it how much they should be given, but they have a responsibility for every stakeholder, given that in the long title is very clearly told that a resolution is for balancing the interest of stakeholders. And here actually we are not selling anything. Somehow many people believe that this resolution process is a sell. The word sell nowhere appears either in the regulation or the code. Code has only one objective, it is resolution. You do resolution with the objective to maximize the value of the assets of the corporate debtor, not a financial creditor. It is not of a sale that somebody will get more and somebody will get less. The corporate debtor continues to exist, if not necessarily as an entity, but its business continues as a going concern. Only some stakeholders are changing. One financial creditor is going, another is coming, one shareholder is going, another is coming, or operational creditor is being substituted. The corporate debtor remains. So when we are talking about the value of the assets of the corporate debtor, I think we may not give as much importance that we maximize the interest of only one set of creditors or financial creditors. So if it were a sell, company is being sold, then your logic applies and one can talk about also sale of assets. Our model is not a sell model. Our model is resolution. We do not want many companies to go into liquidation. Unfortunately, today we have relatively more companies going into liquidation, or we are getting 46%, sir, as you are telling. This is happening today because a new law has come in. Many companies which were in BIFR, in the morning I was giving the example of Synergy Dure, which was in BIFR for 15 years with negative net worth. Even that company, there is a resolution here. That company also didn't go into liquidation. So our objective is that as much as possible, we know new law has come in, very bad companies, not going concern companies have come up. This is expected. This has happened everywhere in the world. Whenever a new law has come up, this backlog has come up, performance has not been good. But despite that, if we have got 46%, as compared to the data what World Bank gives in ease of doing business, 26%, 9%, and 4.3 years. So here we have 46%, 270 days, and less than 1% cost. So we are talking about resolution, and there is no prohibition on having a resolution in piecemeal. So when section 25(2)(h) was amended last round, it was told that you will invite a resolution plan or plans. It was written 2 words, S was added, plan or plans. That means it was made clear that a resolution applicant can submit more than one plan. He can have 5 competing plans for one enterprise, or the resolution professional can invite for each unit. A company has 5 factory premises, one may not be interested in all 5, or let's say a company has 5 product lines. One may not be interested in all 5 product lines. Nothing prevents in the law that he cannot package each of them separately, and he can still give option to people. Please submit resolution plans for each unit, also submit a composite plan. Whatever committee of creditors decide is a voting, it's application of mind, it's not a formula-driven approach that whatever H1 comes up, it will be taken up. So the law today allows all possible permutation and combination. Unfortunately, the committee of creditors and resolution applicants are not becoming innovative. Resolution plan is basically an idea of creation, a creative idea. People have to create ideas and not get stuck up with just getting the recovery upfront. Idea is that business is not doing well. Come up with a plan which may require change of management, change of technology, change of product line, can mean infusion today, tomorrow, all possible permutation, combination, and business is possible. That's why you wanted the responsibility of the financial sector who can take business decision. So instead of that, as long as you are focused only on recovering the money for financial creditors, you will talk about to sell. So we are not talking about sell at all. We are interested in saving the company, and that is what in the matter of SR, Honorable Supreme Court has told. If there is any person who can save the company, every effort must be done to save the company. And you know, even that synergy Dura I told, where the creditors were to get 900 crores, they got 54 crores, which is 6%. But they got 600 times of the liquidation value, and that saved the job of 1,500 people. So that is what we are interested. We are not interested in selling and some financial creditor taking maximum possible or having the least haircut and get away. Thank you.
Good evening, one and all. My job is to propose vote of thanks to each and every one of you. This is one of our initiatives at IBBI to spread the knowledge of the law and to learn from the experience of the players from the market and associate with stakeholders so that the takeaways from these opportunities would strengthen in building capacity, knowledge, experience, and adding value to the day-to-day administration of insolvency and bankruptcy market that has evolved in this country. VIDHI has been in the forefront for a long time, for about 5 years in giving a shape or fine-tuning the governmental, legal and regulatory processes, and they have contributed a lot in drafting some of the regulations and also refining them. So when VIDHI proposed this, we readily agreed because they have a stake in this and they continue to be in the process even today. The law, Insolvency and Bankruptcy Code, is the brainchild of none other than our Honorable Finance Minister, Mr. Arun Jaitley. In his first budget speech after this government was formed in 2014-15, there was a reference of new insolvency and bankruptcy regime for the MSME, which later transformed into a bigger and better policy covering all the stakeholders. And now that you have the Insolvency and Bankruptcy Code, which deals with the insolvency of the corporates, individuals, and all the other stakeholders. So it was our privilege and honor to have him in the morning to inaugurate this, and we are lucky and fortunate that we could get him amidst his busy schedule, especially when Parliament is in session. So let me propose my vote of thanks to him for blessing this conference in the morning on behalf of IBBI, VIDHI, and on my own behalf. Let me come back to the chief guest of this valedictory session. You know, Honorable Mr. Dr. Rajiv Kumar is a very busy policy maker as head of the think tank of the policy in the country, we thought it would be very difficult for us to get him. And amidst his busy schedule, we are fortunate to have him here in the afternoon and then listen to him and to clear some of the doubts we have been in our mind. And I'm sure that all of you must have enjoyed the speech. And I think this is an opportunity for the policymakers, the think tank, also to have some takeaways from conferences like this, where there were references of 29A, treatment of operational creditors, and things like that. I think this would help the think tank, the policy evolution, and to help in evolving the right policy. So let me propose vote of thanks on behalf of IBBI, Vidhi, and my own behalf. Give him a very big hand. My thanks are all also due to Dr. M.S. Sahu, our chairperson, who has been guiding us in the day-to-day implementation and regulation of this code. And let me also thank each and every one of you, especially the panelists and the moderators, Dr. T.K. Vishwanathan, and all other members who were there, members of the BLRC who were here, who took part in this panel discussions. I thank Mr. Ganeshwar Singh, Joint Secretary, who is a member on our Governing Council, and Mr. P.K. Malhotra, all the professionals, insolvency professionals, lawyers, chartered accountants, my dear colleagues. Thank you very much for making this conference a success. I think we have got something to take home from this conference. Let me thank once again. Thank you very much.
Aishwarya and I would. Okay. Sorry. Please. So Aishwarya and I would also like to exercise the privilege of being MCs and just take 2 more minutes to thank everybody. We'd really like to thank all of our speakers and panelists for flying into Delhi. For many of you who came from Bombay, it was a great privilege for us that you would come for a not-for-profit organization that's just 5 years old, to come all the way from Bombay. Thank you for all the distinguished guests, both who spoke during the sessions as well as participated in the audience. Thank you very much. We would also like to thank IBBI for helping us conceptualize and organize this conference. A special thanks to Dr. Sahu, who lent us his experience and vision in really structuring this conference and hopefully making it a successful conference. And a special thanks to Mr. Saji Kumar, Mr. Vijay Kumar, and Mr. Dhariwal for really helping us organize this in the way that it should be. I'd also like to take a single moment to thank the team at Vidhi for helping us organize this. In particular, thanks to Ramya, Param, and Ulka for really taking on the organizational burden on our behalf. Thank you very much, and so sorry for keeping you.
Thank you.